You have, in this case, illegal aliens from Venezuela sent here by Maduro who are members of a foreign terrorist organization, Tren de Aragua, an organization that the intelligence community has found is operating at the direction of a hostile, adversarial foreign regime carrying out criminal enterprises to destabilize the political system in the United States. Those are the facts when it comes to TDA. So they're all illegal, they're all gang members, they're all foreign terrorists. And now we are being told that they cannot be expelled from our country without an extraordinary amount of individualized adjudication at the district court, circuit court, Supreme Court, up and down, up and down, up and down. No American citizen receives this level of so-called due process. Because it isn't due process. This is called infinity process to keep you here forever. Yeah. That's what this is.
In Article 4, Section 4 of the U.S. Constitution, it says that the federal government has an obligation to defend the states from invasion. But it also doesn't define when exactly it is that that invasion starts. Well, if you go back to Inauguration Day of this year, just about 4 months ago, almost 4 months to the day here, President Trump, in fact, declared an invasion under the INA, the Immigration Naturalization Act, and then later also declared Tren de Aragua to be a foreign terrorist organization and invoked the Alien Enemies Act. So walk us through this. What did the court say? What did the president do? And who's really in charge of declaring when an invasion is an invasion?
So I guess there's two different court cases that are relevant here. There's what the Supreme Court did, and there's what this district court in Colorado also did. I think it was yesterday that the Supreme Court acted over Easter weekend. So what the Supreme Court did was it issued an administrative stay to prevent the deportation of a group of Tren de Aragua migrants. What the district court did was it actually issued a preliminary injunction, I believe, meaning that it did a full reasoned decision, essentially saying that because there was no invasion, and that the President Trump was wrong to declare what was happening at the southern border a predatory incursion, and therefore his invocation of the Alien Enemies Act was invalid. So we can take either of those in turn. They're both wrong for very different reasons. We'll start, I guess, with the district court because that's the easiest one. The district court is wildly over its skis, and I got in an argument with Ed Whelan of the APPC over this. The district court doesn't get to second guess a president's determination that there has been an invasion or predatory incursion into the United States. The district court judge does not have an intelligence agency. They do not have an army. They do not have military intelligence. They have 4 law clerks. And that is not sufficient to put them in a position to have any reasonable way to determine that. The only role that a district court has is to look at the statute, the Alien Enemies Act, and say, has the president made the necessary invocation? Has he made the findings? If the president says there is an incursion, then I have to defer to that. If the president says there is an invasion, I have to defer to that. If they haven't made those invocations, I can say it is legally insufficient. But once those invocations are made, that should be the end of it. This district court judge didn't do that. I'm sure they're going to get reversed. And for some reason, this got Ed Whelan's ire. I thought this was a pretty uncontroversial statement. The idea that a district judge would get to say, well, I don't think the facts on the ground actually meet the general understanding of what constitutes a predatory incursion. They don't get to do that. That's not their role. That's way over the line into Article 2 territory. What the Supreme Court did, they didn't actually issue a reasoned opinion. They just put in place an administrative stay. The reason what the Supreme Court did was so bizarre is they put in place this administrative stay before there had even been any kind of decision rendered by either the district court or the Fifth Circuit Court of Appeals, which is wild. And Justice Alito, in a scathing dissent, called them out on it. This was all about, Alito was basically pointing out that, you guys have talked about the need for the executive branch to follow the law, and here you are throwing out the entire federal rules of appellate procedure to reach for the opportunity to stop the administration from deporting some Venezuelan illegal immigrants. That's crazy. You guys should follow the law.
And so this idea then that they are, and walk us through actually how this is connected, because again, this has been in a law that's been on the books really since the time of the founding fathers. I mean, it's almost as old as the current iteration of the American government itself. It goes back essentially to the ratification of the Constitution. So the idea that this is something that, hasn't been well decided, of course it's been well decided. And I saw, a bunch of liberal commentators saying, well, this is a very old law. I said, well, yeah, so is the First Amendment, but you guys don't seem to have a problem with that. Like, this is our system. So I guess the question then, Will, I would have to say is the Supreme Court coming in and saying that the district court is right, that the president does have this authority, or could it be that the Supreme Court is coming in and potentially showing some signs of daylight that they might be looking at overturning this law on constitutional grounds?
I don't think they have any basis to overturn this law on constitutional grounds, and I don't think anybody's honestly making that argument. So I think that to the extent there's an argument that the plaintiffs are trying to make, they're trying to make this argument that not that the law is invalid, but that the president's findings are insufficient, meaning the president's wrong to say there's an invasion, so therefore he's not allowed to invoke this act. That's the basic plaintiff argument, as I understand it. It's a pretty ridiculous argument to say that this statute is unconstitutional. That's absurd. I mean, it was not only does it obviously fit squarely within the powers of the president under Article 2 to deal with our foreign affairs, to respond, to declare, handle, be the commander in chief of the military, et cetera. But it's also the fact that it's a old law is actually a really good indicator that it is constitutional, because it's the very founding generation that wrote the Constitution and that ratified the Constitution that passed this law. If they thought it was unconstitutional, it would have gone away long ago, but it never did. It's been on the books since the founding, in the same way that as you say, the Bill of Rights has been on the books since the founding. So, I don't think you're ever going to see a world where they find it unconstitutional. But I think the thing, there is something to understand here. The Supreme Court hasn't really ruled much on the Alien Enemies Act, other than what they did in overturning James Boasberg. In that ruling where they said James Boasberg in DC had no jurisdiction, they said that there does need to be notice, individualized notice, to the people who are about to be removed pursuant to the Alien Enemies Act, and they need to have a sufficient amount of time to file a habeas corpus claim. That's the extent of what the Supreme Court has said about the Alien Enemies Act. They haven't said anything about, overturning the president's finding that there is an invasion or predatory incursion, and I don't think they will. I think this district court judge that thought she had the right to do that is going to find herself reversed very quickly. I don't even know that it'll get to the Supreme Court. I think she'll just get reversed by the 10th Circuit.